Bystanders who watched the moments leading up to George Floyd's death recalled feeling helpless and frustrated in the presence of police during day 2 of former Minneapolis police officer Derek Chauvin's murder trial. Yesterday, witnesses shared emotional testimony after being asked by prosecutors what it was like to watch Floyd struggle for breath under the cop's knee. Meanwhile, the defense focused on humanizing their client by highlighting the conditions under which Chauvin was acting. For more on this, let's bring in CBS News legal expert and analyst, Rikki Klieman. Rikki, I want to ask you, I've been thinking about this all morning long. All yesterday I was thinking about this because the soundbite that we heard leading almost every single broadcast, national and local, the newspapers, was the young 17-year-old at the time woman who's now 18 years old, who was asked by the prosecutors what she felt like when she watched George Floyd under the knee of Officer Chauvin. And I was reminded as I was watching that was a I don't know what you call them in the legal business, but like it was a follow-up cross-examination after Derek Chauvin's attorney seemed to suggest that because her video was the one that was used by everybody, including the prosecution, to highlight what had happened, that somehow she had gained some sort of I don't want to use the word fame, but that she'd become known because of this notoriety, because of this video, trying to paint her as somebody whose life had changed because she filmed this video. And that allowed the prosecution to come back up and say, yeah, tell us, young lady, how your life has changed. And it just made me think, did you think that was an error by Derek Chauvin's attorney?
When I watched this, I watched it both as a citizen, because I want to know the whole story, but I also watch it as a lawyer. And when you watch it as a lawyer, one of the things that you would say is, number one, why didn't the defendant's lawyer file a motion to keep out any of the evidence about later thoughts of any of the eyewitnesses? They are irrelevant in terms of evidence to a trial. One of the other things that I thought, and I certainly get texts all the time from my former law partner as well as other lawyers, is exactly what you point out, Vlad, which is to say, oh, this is really trouble. Why did he go down this track as a defense lawyer? Because he has, as we say in the law business, opened the door to redirect. And the redirect examination was just chilling. The reaction of a youngster, whether she was 17, now 18, let alone a 9-year-old, those kinds of young witnesses and child witnesses, if you watch and listen to their anguish and you're a juror, it has to hit you not only in your head, but in your heart and in your gut. And those are the kinds of witnesses who will persuade the jury to convict of the top count. So the defense has to walk a very, very narrow road here. And unfortunately, the road they walked down was a major highway.
Just because, and the only reason I asked that, Rikki, is because that was that young lady's opinion. And I know that in court, you're not supposed to give your opinion. But when the defense attorney asked her about what happened in the aftermath of showing that video to the world, didn't that leave the prosecution the ability to ask her opinion and to leave it in the record?
Precisely. It's one of the issues I say as a lawyer, where I start to just shake my head and sometimes pound the table, because we have heard the opinion of every eyewitness. The point of a prosecution's direct examination is to say, what did you see? What did you hear? What did you do? It is not to say, what did you think? And how did you reflect? And so you can't do that in a court of law according to the rules of evidence unless the defense attorney opens the door, which he did.
Let me ask you a little bit about the defense's strategy with some of the other witnesses. Eric Nelson, who was a witness there, he's also an MMA fighter. Donald, there was sort of these long questions about his training and his expertise, and did you train with law enforcement versus did you train law enforcement? What do you know, what don't you know? And then there's the off-duty firefighter as well, who was questioned. And what it seemed like the defense was trying to do is suggest that their presence and their behavior at the scene, as they were trying to, you know, shout their concerns about the condition of George Floyd, that was actually sort of making the situation worse. I want to ask you what you made of that strategy, because when I was listening to it, I was thinking, but what does that have to do with what we're actually talking about here? What does that have to do with a knee on George Floyd's neck? But I wasn't sure if this was an attempt at maybe turning the jury a little bit against them. But I don't know. You're the expert here. What do you make of that strategy?
Let's deal with Mr. Williams, the martial arts expert, first, and then go to the off-duty firefighter. With Mr. Williams, I do think that the defense had a strategy. I don't think it was carried out very well. The strategy was to make him a martial arts expert. So when they asked those ultimate questions, which frankly probably got lost to the public, but not lost to the lawyers, the ultimate questions had to do with the fact that when you saw someone go unconscious from a particular hold in martial arts, would they ever regain consciousness and come up fighting? And the answer to that was yes. That was a huge point for the defense. If you read the news, watch the news, it was totally lost. Because there was so much else that was extraneous in cross-examination. The idea that the defense lawyer might have been trying to show that this was a menacing crowd or an interfering crowd. When you look at the video, I mean, it's just a small group of diverse people who are simply saying, get off of him. He can't breathe. Get off of him. It was hardly menacing in any way. So let's get to the off-duty firefighter, who was, as they all were, extraordinarily powerful for the prosecution. The off-duty firefighter, again, to look back to Vlad's question, again gets to give her opinion about everything that should have happened. That is how this man, George Floyd, on the ground, how he should have been cared for immediately and by the paramedics and by the firefighters. Well, she wasn't called as an expert witness. She was called as a fact witness. So it should have been what she saw, what she heard, perhaps what she said if it is on the video. What happened there is that the defense, I think, was trying to make her out to be a busybody, someone who was getting involved in something she shouldn't have been involved with. Well, that idea is going nowhere. And if anything, of course, it backfired on the defense. You have a woman who was literally stricken. She is emotionally in anguish by what she saw, and again, giving her feelings in retrospect that she wished she could have done more. She wished that she had simply intervened to save him. Well, we know, those of us who have worked in the court system with police and fire before, when the police have charge of what is considered a crime scene or a person being put under arrest, no one is allowed within that parameter, including an off-duty firefighter who has no proof that she's an off-duty firefighter or is not producing any proof. So of course the police are going to say to themselves, look, we have this under control. You can't get involved here, and we don't really know if you're an off-duty firefighter. Unfortunately for the defense, if you're looking at this in terms of trial tactics, we didn't get any of that. What we got was a woman who is going to live with watching that death for the rest of her life and feeling that somehow she should have done more. We got that same opinion from these emotionally heart-torn witnesses who will never forget what happened when they watched a man die in front of them. All of that, if I say it as a journalist, all of that is the story, and is the story that America wants to hear. They want to know what happened and how these people reacted. However, in a court of law, if you had a defense lawyer who kept this testimony, all of it, tight, we would never have heard any of that emotion about afterwards.
It's going to be really interesting to see how things unfold today, Rikki. There'll be more witnesses on the stand. I was thinking to myself, I wonder if this, you know, when we look at the trial sort of over the coming days and weeks, if this might actually work out for the defense, in that it seems like a lot of the witnesses are right up front, right out of the gate. I presume that the defense is going to be leaning on experts, technical stuff, the kind of a testimony that's not anywhere near as emotional as what we're seeing right now. Maybe their hope is that you know, the jury, the sting of what they're hearing at the beginning of the trial will sort of dissipate further on. We'll see. Once again, I'm not an expert, just guessing. But Rikki, I know we're going to continue to talk to you right now. We got to get some other news in, so thank you so much for joining us.
Thank you.